Hello, I wanted to talk about one of the places that most people fear, which is a courtroom. Okay, to them, most people, court means conflict, court means punishment, court means debt or prison. But what if I told you that court can actually be a place of remedy? That a judge is not just there to rule, but can act as fiduciary, trustee, or even record keeper. So today, what we're going to do is we're going to break the illusion and show you how courtrooms are tools, not threats. I know it's hard to believe because, a lot of time when you go into court, they're railroading you. They're doing things that seem to be wrong or incorrect. But that's why we have to learn how to use our trustees or how to manage courts or people who are facilitating debt collections, etc. So I'll get to it. A court is just a form, but what kind? Okay, so a court could be a court of law. A court of law, historically, a court of law is with the power to grant monetary damages. Traditionally, English courts followed a distinction between courts of law and courts of equity, which could only grant remedies other than monetary damages, including injunctions, writs, or specific performance. This distinction has now largely been dissolved in the United States adoption of Federal Rules of Civil Procedure in 1938. So just like in my last video, if you go and read Rule 1 of the Federal Civil Procedures, and then you read Rule 2, it is talking about the establishment of civil law, which is an infusion of law and equity, which happened in 1937 and was finalized in 1938, gave the courts a combined jurisdiction over matters of law and equity. Thus, almost all courts today, with exceptions of bankruptcy courts and certain state courts, perhaps most famously the Delaware Court of Chancery, are deemed as courts of law that can consider all remedies, monetary or otherwise. A court of law may also be used to refer to a court that decides cases on the basis of law. Now, this definition is coming from Wexlaw or Cornell. So we have to understand that a court can also be used as a court of equity. A court of equity is a type of court with the power to grant remedies other than monetary damages. These remedies include injunctions, writs, or specific performance, among others. Traditionally, English courts followed a distinction between courts of law, which could grant exclusive monetary damages, and courts of equity, which could not. The Court of Chancery was an example of an early English court of equity. The distinction between the two types of courts has now largely been dissolved. In the United States, the adoption of the Federal Civil Rules of Procedure in 1938 gave the courts a combined jurisdiction over matters of law and equity. Bankruptcy courts and certain type of other courts, so in Delaware, Mississippi, New Jersey, and Tennessee, can be considered as remaining examples of courts of equity. This definition also comes from Wexlaw or Cornell. Court can also be used as a commercial tribunal, enforces contracts and obligations. A commercial tribunal is also known as a commercial court or a business court. A specialized court that handles legal disputes related to commercial law and business matters. These tribunals are designed to provide efficient and specialized resolution of business disputes, often involving large, complex cases. So when you hear people say that I am not engaged in a commercial activity, I am not engaged, they may not understand why they're saying it, but they understand the process of saying this to limit the scope of the court's enforcement of authority. Okay, so when you limit the scope of what a court, and this is not legal advice, but when you limit the scope of what a court can do or what the court can, use as evidence, or what the court can't, the authority of the judge, that can change the dynamic of a case. An administrative venue which enforces agency policies. That's usually what you get in traffic court. If you don't define what court you're in, the system assumes for you. And that's where people get trapped. So usually if you go to court, people will say they're not listening to me. I'm filing these motions. They're not things. If you filing motions and stuff in court and they're not listening, what would you do? If you go into Burger King and you talk to the cashier and the cashier is not giving you, honoring the coupon or whatever, you go speak to the manager. A judge is not always a ruler. Sometimes they're just an administrator. They can play multiple roles. An executor of a trust. This definition is also going to come from Wexlaw or Cornell. So if you want to do your own research, that's why I'm leaving you where I'm getting these definitions. I'm not going to old school Black's Law dictionaries, Bovier's, because this is just a basic overview to educate everyone. An executor is someone named in a will as the person who will carry out the testator's formal wishes. Typical duties of an executor include paying outstanding taxes, debt, and distributing any remains assets among the testator's heirs. While the executor handles the actual distribution of the testator's assets, they are legally bound to distribute said assets in accordance with the testator's wishes. Hint, hint, who's the testator? As a fiduciary in equity, a judge can play the role of as a fiduciary in equity. A fiduciary, derived from the Latin term of trust, is a person owing a fiduciary duty to another. When someone has a fiduciary duty to someone else, the person with the duty must act in a way that will benefit someone else financially. Owing a fiduciary duty to a party creates a fiduciary relationship. So, the judge can also act as an administrator of a case, also a mediator between parties. When you file properly assert your role and express your equity, you shift the judge's role. They must respond to your position, not your silence. So a lot of times when we go into court, we leave a lot of presumptions and then we don't challenge or change the scope of the court. And then we go into court and we're really not knowing what to expect. And that's what I think is the main problem with a lot of people. I think when they go into court, since they don't limit the scope of the court or limit the judge's authority, the judge assumes it. And this creates this big, huge body of law that this judge can enforce. And he may not even know, or she may not even know what they're doing. So I thought this video would be very helpful for that. All right. So you can go to court for multiple reasons. And I'm going to give you just 6 reasons or 6 ways a court can be used. There's many. OK, this is just a video for people to get an educational foundation in. OK, to settle a trust or a contract, you can file a dispute or a contract claim to settle rights, not just argue breaches. OK, a lot of people may not know this. And this is very important information that you do want to know. To create a public record. Some of the people who have done consultations with me, I've informed a lot of you guys that some of your administrative processes can be just filed in the court. I didn't say you had to go in and argue. OK, so I just want to make that clear for people. You can enter an affidavit, a notice, or a declaration into the record, and the court preserves it as the truth unless rebutted. To enforce fiduciary obligations. If someone owes you a duty, landlord, trustee, creditor, the court can compel them to act in good faith. To rebut a presumption. So if someone calls you like a criminal, you can rebut that you're a criminal. If someone makes a slanderous claim towards you, you can rebut it. That's what I tell people. You have to rebut the presumptions. But I understand it's hard when you're going into court. And a lot of times, this is a lot of information to jam on somebody and give them in the last minute. OK, if you're being presumed as a debtor, defendant, or a ward, that the court is where you file your rebuttal. To petition for injunctive relief, you can ask the court to stop harm, like illegal collections, illegal evictions, or illegal enforcements before they happen. Okay? So a lot of times when people get into contracts, they may not understand that as soon as you get in the contract, as soon as you send a notice to the other party that something is illegal or something is incorrect, and they act as if they don't have to respond, boom. There's other ways to do this, but I'm just giving you the most simple way for most people. Okay. The sixth way is to record your status and standing. Through affidavits and notices, you can establish a role as the creditor, beneficiary, or living person, altering how a court must handle your case. So, what we're going to do is talk about how you can flip the role. It's not about the name on the paper. It's about the role you choose to stand in. You can stand as a defendant, creditor in equity. The reason why a defendant is a creditor in equity is because the defendant has not raised a claim. So that's why the court, usually when you file a initial case, the court will give the defendant a free opportunity to do a counterclaim within that case. Okay? In some states, they may charge, but you can waive it or other ways to do it. But I'm not going to go over all that. Okay? The debtor, even the debtor, has rights in court. The debtor can be presumed as a beneficiary of a trust, or as I call it, an unsecured creditor or unnamed creditor. Tenant, contributor with equitable interest. Accused, surety acting in good faith. The moment you express your rights, the court must treat you differently. And if they don't, they've breached fiduciary duty. Okay? So just because you lose in a court case, they rule against you, they're giving you hell, you need to express that they breached their fiduciary duty to you, which is an obligation to the public, not to private creditors or private people. Okay? So, myth. We're going to go over some of the myths in courts. The first myth is that the judge doesn't care. Let's go with the fact. The judge is bound by the record. You may hear me say this many times, that a judge is bound by the record, not what you presume that the judge is supposed to do, and not what the other party's presuming that the judge is supposed to do. If you don't create it, they can enforce your truth. Myth. Court is only for lawsuits. Fact. Court is where you settle all matters, including trust, status, title, remedy, and harm. Myth. I need a lawyer to be heard. Fact. You need to express standing in equity or express any rights you have. The court cannot ignore properly presented truth. So for some of you guys who are kind of nervous about going into court, dealing with court officials, there are always remedies for when a court breaches your rights. So a lot of times when you go into court, you may have to escalate it to a higher court, or you may have to bring a claim in a different court, or you may have to challenge what was done in that court to assert your rights. But you must know your rights, regardless of what role you're playing. That's one of the key reasons why I made the video. Know your character. Because once you know your character, if you say I'm a defendant, then I'm going to learn how to fight as a defendant, or I can change my role. Okay? So I'm just going to appreciate you guys for watching this video. And if you like it, you can subscribe. You can hit the bell, and it's going to be more content. I'm going to come with more fire for you. So you were never meant to beg for justice. Remember that. You were meant to administrate it, or administer judgment. Administer your own justice. The court is your tool, not your master. Learn the jurisdiction, speak your role, and bring your remedy, not just defense. And with that being said, I want to thank you guys for watching the channel. And I hope that you enjoyed this. And I hope it was informative.